Exclusive original jurisdiction in family court is Article 3, 4, 5, 6, Part 1, 7, and 10. Article 3, juvenile delinquent. Article 4, support. Article 5, paternity and support born out of wedlock. Article 6, permanent termination of parental rights. Article 7, person in needs of supervision. Article 10, child protective abuse and neglect. Proceedings in the family court outside the city of New York involving juvenile delinquents involving designated felonies shall have preference over every other proceeding except in Article 10, child protective. Family court judges may do a few things. They can administer oaths and take acknowledgments or designate an official to do so. They can issue subpoenas and do subpoenas duces tecums. They can issue a warrant or other process to secure an appearance, like a summons. They can hear and decide motions relating to child support subpoenas. When a person appears in family court and requests a temporary order of protection, that person is entitled to file a petition without delay on the same day he appears, and a hearing must be held either that day or the next day family court is open. Where an officer is unable to complete service of a temporary order of protection, he should submit an affidavit or a certificate or an affirmation of the attempted service containing the name of the party attempted to be served, the papers he attempted to serve, the date and time he attempted to serve, and the address where he attempted to serve. If no address, then the place and the manner attempted to serve. A desk officer may take cash bail from any person arrested pursuant to a family court warrant, provided such arrest occurs between 11 a.m. and 8 a.m. the next morning, except in New York City shall be taken between 2 p.m. and 8 a.m. the next morning. The amount of cash bail shall be fixed on the warrant. Family court may place in protective custody a person under 16 who is a material witness. So a material witness is 15 years old or younger. No order of protective custody may extend for a period of more than 14 days. For good cause shown, the court may review the order for an additional period of 14 days, but the total period of protective custody may not exceed 42 days. If a child under 16 is placed in protective custody as a material witness pursuant to a family court order, said order may extend for a period of no more than 14 days. OCA may enter into an agreement with a legal aid society for the society to provide attorneys to represent children in the family court or appeals in proceedings originating in the family court. An agreement may be terminated by OCA by serving notice on the society 60 days prior to the effective date of the termination. No designation may be for a term more than 1 year. A minor who is a subject of a juvenile delinquency, Article 3, or a person in needs of supervision, Article 7, or in any proceeding where a minor is detained under or governed by the Interstate Compact for Juveniles, shall be presumed to lack the requisite knowledge to waive the appointment of an attorney. This presumption may be rebutted after an attorney has been appointed, and the court determines, after hearing at which the attorney appears and participates, and upon clear and convincing evidence, that A, the minor understands the nature of the charges, the possible dispositional alternatives, and the possible defense to the charges. B, the minor possesses the maturity, knowledge, and intelligence necessary to conduct his own defense. And C, waiver is in the best interest of the minor. So, in order for a minor to waive counsel, the court must find, among other things, that the minor possesses the maturity, knowledge, and intelligence necessary to conduct his own defense. The standard of proof at such hearing is clear and convincing. Who has the right to the assistance of counsel if he can't afford it? The following respondents have the right to free counsel. Respondent in Article 3, juvenile delinquent. Respondent in Article 5, paternity. Respondent in Article 6, Part 3, custody. Respondent in Article 7, persons in need of supervision. Respondent in Article 8, family offenses. Respondent in Article 10, child protective. Respondent in 10A, permanency. The following petitioners have free counsel. Petitioner in Article 8, family offense. Petitioner in Article 10, Part 8, visitation of minor. The following people also are entitled to free counsel. The parent, foster parent, person having physical legal custody of a child in Article 10, 10A, child protective. A non-custodial parent or grandparent served with notice, Social Services 384. The parent seeking or contesting custody. The parent who opposes an adoption. Any person where an order is being sought to hold such person in contempt of court. Destitute children in proceedings under Article 10C. A minor in a protective custody. Youth under 21 in Article 10B. That's 0 to 20 is entitled to a free attorney. 21 is not entitled to a free attorney. Also, a judge may assign counsel if he determines that such assignment is mandated by the Constitution of the State of New York or the United States. Free counsel, respondents 3, 5, 6, Part 3, 7, 8, 10, 10A. Petitioners 8, 10, Part 8. Parent 10, 10A. Non-custodial parent, Social Services, or grandparent, Social Services. Parent seeking or contesting custody. Parent who opposes adoption. A person who is being held in contempt of court. Destitute children under 10C. A minor in protective custody. A youth under 21 in 10B. That's 0 to 20 in Article 10B. A judge may assign counsel if he determines such assignment is mandated by the Constitution of the State of New York or the United States.